Imagine for a moment that a police officer pulls you over on a quiet street. Your heart rate climbs. You are not sure what you have done wrong. The officer asks you to step out of the car. He asks to search your belongings. You do not know whether you are allowed to say no. You do not know what your rights are in that exact moment. And because of that uncertainty, you comply with everything, even things you were not legally required to do. This situation happens to millions of Americans every single year. And the tragedy is not just the encounter itself. The tragedy is that most people do not know where police power ends and where their own constitutional rights begin. Today, we are going to change that. Welcome. In this video, we are going to go deep into one of the most important and misunderstood topics in American law, the balance between police power and the rights of every citizen. We're going to take this slowly, clearly, and completely. By the end of this video, you will understand what the police can legally do, what they cannot legally do, what your rights are under the United States Constitution, and exactly what you should know to protect yourself, lawfully, calmly, and intelligently. This is not about hating the police. This is not about breaking the law. This is about understanding the law, which is something every single American deserves to do. Let us start at the very beginning. Where does police power in the United States come from? Most people assume it comes from the federal government, from Washington, D.C., from Congress or the president. But that assumption is incorrect. Under the United States Constitution, police power is primarily a power of the individual states. The 10th Amendment makes this clear. It says that powers not given to the federal government are reserved to the states or to the people, and the power to protect public health, public safety, public morals, and public welfare, that is the core of what legal scholars call the police power, belongs to each of the 50 states. This is why laws about crime, traffic, property, and public order differ from state to state. California's laws are different from Texas's laws. New York is different from Florida. The federal government does have law enforcement agencies, the FBI, the DEA, the Secret Service, but their authority is narrower. It is focused on federal crimes, crimes that cross state lines, crimes involving federal property or national security. The police officer on your local street corner operates under the authority of a state, a county, or a city. Now, here is the critical question. If states have this power, what limits it? What stops a state from giving its police officers unlimited authority? The answer is the United States Constitution, specifically the Bill of Rights and the 14th Amendment. These are the guardrails. These are the boundaries that no police officer, no state law, and no government authority can cross. Understanding these boundaries is everything. The Fourth Amendment to the United States Constitution is the one that governs most police-citizen encounters. It reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." That phrase, unreasonable searches and seizures, is the heart of the matter. What does this mean in practice? It means that in most situations, a police officer cannot search you, your car, or your home without either your consent, a valid warrant, or what the law calls probable cause. Let us define each of these carefully. A warrant is a written order from a judge that specifically authorizes police to search a specific place or seize a specific thing. To get a warrant, police must go before a judge and show probable cause, meaning they must have real, specific, articulable facts that suggest a crime has been committed and that evidence will be found in that location. A hunch is not enough. A feeling is not enough. There must be real evidence. Probable cause can also allow police to act without a warrant in certain emergency situations. For example, if an officer is chasing a suspect and the suspect runs into a building, the officer may follow without waiting for a warrant. If police are lawfully somewhere and they see evidence of a crime in plain view, they may seize it. These are called exceptions to the warrant requirement, and courts have recognized several of them over the decades. Now, here's something absolutely critical that most people do not know. You have the right to refuse consent to a search. If a police officer walks up to you and asks, "Can I look inside your bag?" you are legally allowed to say, "No, I do not consent to a search." The officer cannot punish you for refusing. Refusing consent is not obstruction. It is not suspicious behavior. It is the lawful exercise of a constitutional right. However, and this is very important, if the officer has probable cause or a warrant, they can search anyway. Your refusal to consent only matters when they don't have independent legal authority. By refusing, you preserve your legal rights for any future court challenge. The Supreme Court case Terry v. Ohio, decided in 1968, introduced another critical concept, the stop and frisk. This ruling said that if a police officer has reasonable suspicion, a lower standard than probable cause, that a person is involved in criminal activity and may be armed, the officer may briefly stop that person and pat down the outer clothing to check for weapons. Notice the word reasonable. It must be based on specific observable facts. An officer cannot stop and frisk you simply because of the color of your skin, your clothing style, or the neighborhood you're in. That would be unconstitutional discrimination. You have almost certainly heard the phrase, "You have the right to remain silent." This comes from the Fifth Amendment, which says that no person shall be compelled in any criminal case to be a witness against himself. In plain language, you do not have to answer questions that could incriminate you. You cannot be legally forced to confess or to provide information that will be used against you in a criminal case. The Supreme Court's landmark 1966 decision in Miranda v. Arizona made this right real and enforceable. The court ruled that before police can interrogate someone who is in custody, they must inform that person of their rights. These are the Miranda rights: the right to remain silent, the warning that anything they say can be used against them in court, the right to have an attorney present during questioning, and the right to have an attorney appointed if they cannot afford one. If police fail to read these rights before a custodial interrogation, any statements the person makes may be thrown out in court. Here's the nuance that most people miss. Miranda rights only apply when two conditions are both true. First, the person must be in custody, meaning they are not free to leave. Second, the person must be under interrogation, meaning police are asking them questions designed to elicit incriminating responses. If you are not in custody, for example, if you're just stopped briefly on the street, police are not required to read you Miranda rights. But your Fifth Amendment right to silence still exists. You can still choose to not answer questions. After the 2013 Supreme Court case Berghui v. Tompkins, however, there is an important rule. You must affirmatively invoke your right to silence. Staying silent alone may not be enough. You should clearly and calmly say, "I am invoking my right to silence," or "I wish to speak to an attorney." The Sixth Amendment gives you the right to have an attorney, a lawyer, represent you when you are facing criminal charges. This is not just a courtesy, it is a fundamental protection. And under the Fifth Amendment framework of Miranda, you can invoke the right to an attorney even before charges are filed, as soon as you are in custody and being questioned. One of the most painful and debated topics in America today is police use of force. The law does grant police officers the authority to use force, but only under strict conditions. The guiding legal standard comes from a 1989 Supreme Court case, Graham v. Connor. The court held that the use of force by police must be objectively reasonable under the circumstances. This means courts look at what a reasonable officer would have done in that exact situation, with the information available at that moment in time. Factors that courts consider include how severe the alleged crime is, whether the suspect poses an immediate threat to the safety of officers or the public, and whether the suspect is actively resisting arrest or attempting to flee. The more serious these factors are, the more force may be justified. But force must always be proportionate. An officer cannot use deadly force simply because someone is running away from a minor offense. An officer cannot use force as punishment for mouthing off or being disrespectful. Excessive force, force beyond what is objectively necessary, violates the Fourth Amendment. And under 42 U.S.C. Section 1983, a federal civil rights law, individuals can sue police officers and government entities for violating their constitutional rights. This is a legal remedy, a legal tool that citizens can use when their rights have been violated. The doctrine of qualified immunity, however, has historically made it difficult to win these lawsuits. Qualified immunity protects officers from personal liability unless they violated a clearly established constitutional right. This doctrine remains highly controversial and is actively being debated in legislatures across the country. An arrest is one of the most significant things that can happen in a police-citizen encounter. An arrest is not the same as a detention. A detention is a temporary stop. Police briefly hold you for investigation. An arrest means you are being taken into official custody on suspicion of committing a crime. For a lawful arrest, police generally need either an arrest warrant or probable cause to believe you have committed a crime. The moment you are placed under arrest, your constitutional rights become paramount. You have the right to be informed of the charges against you. You have the right to remain silent. You have the right to an attorney. You should not physically resist arrest, even if you believe the arrest is unlawful. The time to challenge an unlawful arrest is in court, through your attorney, not on the street. Resisting arrest, even wrongfully, creates additional legal problems and can escalate the situation dangerously. After an arrest, you have the right to be brought before a judge without unnecessary delay. This is called your right to a speedy first appearance or arraignment. You have the right to know the evidence against you. You have the right to bail in many cases, and you have the right to a jury by your peers if you are facing serious criminal charges. This is guaranteed by the Sixth Amendment. The 14th Amendment, ratified after the Civil War in 1868, is also enormously important here. It says that no state shall deprive any person of life, liberty, or property without due process of law, and no state shall deny any person the equal protection of the laws. These two clauses, due process and equal protection, are the constitutional backbone of the fight against racial profiling, discriminatory policing, and any government action that treats people differently based on race, religion, national origin, or other protected characteristics. Now, let us bring everything together with real, practical guidance. If you are ever stopped by police, here is what legal experts consistently recommend. Stay calm. Keep your hands visible. Do not make sudden movements. Announce what you are going to do before you do it. I am reaching into my glove compartment for my registration. Being calm and clear reduces the chance of a situation escalating. You have the right to ask, "Am I free to go?" If the officer says yes, leave calmly. If the officer says no, you are being detained, and you should say clearly, "I am going to remain silent and I want to speak with an attorney." After that, exercise your right to silence. Do not argue, do not explain, do not try to talk your way out. Anything you say, even innocent things, can be used against you. Do not consent to a search if you do not want to be searched. Say clearly, "I do not consent to a search." You do not need to be aggressive or rude. Simply, calmly, clearly state your position. If the officer searches anyway, do not physically resist. You can challenge the search in court later. Your attorney can argue that any evidence found in an unlawful search should be suppressed, meaning thrown out, under the exclusionary rule, which comes directly from Fourth Amendment jurisprudence. Document everything you can, safely and legally. In most states, you have the right to film police officers performing their duties in public. Do not interfere with their work, but do record when you are able. This documentation can be vital in any future legal proceeding. And finally, know your local laws. States vary, cities vary. The legal landscape is not identical everywhere. Laws around stop and identify, for example, whether you are required to tell police your name when stopped, differ by state. In some states, you must provide your name if police have reasonable suspicion you were involved in a crime. In others, there is no such requirement. Knowing your state's specific rules gives you an enormous advantage in any encounter. The tension between police power and individual rights is not a bug in the American system, it's a feature. It was designed this way deliberately. The founders of this country had experienced the abuse of unchecked government authority firsthand. They wrote the Bill of Rights precisely because they understood that power, without limits, corrodes justice. Every amendment we talked about today, the 4th, the 5th, the 6th, the 14th, every single one of them exists because someone, at some point in history, suffered the consequences of a government that had no restraint. But rights are not self-enforcing. They only protect you if you know them. They only work if you exercise them calmly and intelligently. And they only improve over time when citizens hold the system accountable, through the courts, through voting, through peaceful advocacy, and through education. What you have learned today is not just legal information, it's civic power. It's the kind of knowledge that belongs to every person living in a free society. The relationship between police and the communities they serve is complex, deeply human, and often deeply strained. Most officers serve with integrity, some do not. The law is the framework that governs both, the framework that separates authority from abuse. Understanding that framework is how you protect yourself, how you help others, and how you participate in the ongoing, unfinished work of making justice in this country real for everyone. If this video gave you something valuable, if it clarified something you didn't understand before, or confirmed something you already believed, please share it. Share it with someone who needs to know this, a friend, a family member, a younger person just starting to navigate the world. This information is too important to keep to yourself. Leave a comment below telling me one thing you learned today that surprised you, or one question you still have. I read every comment, and your questions help shape future videos. Subscribe to this channel if you want more content like this, deep, clear, honest explanations of the laws and systems that shape your life. And until next time, stay informed, stay calm, and know your rights.